Consequently, the Court is of the view that Israel has not sufficiently addressed and dispelled the concerns raised by its military offensive in Rafah. In light of the considerations set out in the preceding sections of the order, and taking account of the provisional measures indicated in its orders of January 26, 2024 and March 28, 2024, the Court finds that the current situation arising from Israel's military offensive in Rafah entails a further risk of irreparable prejudice to the plausible rights claimed by South Africa, and that there is urgency in the sense that there exists a real and imminent risk that such prejudice will be caused before the Court gives its final decision. The Court concludes, on the basis of the aforementioned considerations, that the circumstances of the case require to modify its decision set out in its order of March 28, 2024. The Court recalls that in accordance with Article 75, Paragraph 2 of its rules, when a request for the indication of provisional measures has been made, it has the power under its statute to indicate measures that are not in whole or in part other than those requested. In the present case, having considered the terms of the provisional measures requested by South Africa and the circumstances of the case, the Court found that the measures to be indicated need not be identical to those requested. The Court considered that, in conformity with its obligations under the Genocide Convention, Israel must immediately halt its military offensive and any other action in the Rafah governorate which may inflict on the Palestinian group in Gaza conditions of life that could bring about its physical destruction in whole or in part. The Court recalls that in its order of January 26, 2024, it ordered Israel inter alia to, I quote, take effective measures to prevent the destruction and ensure the preservation of evidence related to allegations of acts within the scope of Article 2 and Article 3 of the Genocide Convention, end of quote. In the present circumstances, the Court is also of the view that, in order to preserve evidence related to allegations of acts falling within the scope of Article 2 and Article 3 of the Genocide Convention, Israel must take effective measures to ensure the unimpeded access to the Gaza Strip of any commission of inquiry, fact-finding mission, or other investigative body mandated by competent organs of the United Nations to investigate allegations of genocide. The Court also considers that the catastrophic situation in Gaza confirmed the need for the immediate and effective implementation of the measures indicated in its orders of January 26, 2024 and March 28, 2024, which are applicable throughout the Gaza Strip, including in Rafah. In these circumstances, the Court finds it necessary to reaffirm the measures indicated in those orders. In so doing, the Court wishes to emphasize that the measure indicated in paragraph 51, 2a of its order of March 28, 2024, requiring, I quote, the unhindered provision at scale by all concerned of urgently needed basic services and humanitarian assistance, end of quote, necessitates that the respondent maintain open land crossing points, and in particular the Rafah crossing. In view of the specific provisional measures it has decided to indicate, the Court considered that Israel must submit a report to the Court on all measures taken to give effect to this order within 1 month from the date of this order. The report so provided will then be communicated to South Africa, which shall be given the opportunity to submit to the Court its comments thereon. The court recalls that its orders on provisional measures under Article 41 of the statute have binding effect and thus create international legal obligations for any party to whom the provisional measures are addressed. The court underlined that the present order is without prejudice to any findings concerning the respondents' compliance with the orders of January 26, 2024 and March 28, 2024. In its orders of January 26, 2024 and March 28, 2024, the court expressed its grave concern over the fate of the hostages abducted during the attacks in Israel on October 7, 2023, and held since then by Hamas and other armed groups, and called for their immediate and unconditional release. The court finds it deeply troubling that many of these hostages remain in captivity and reiterates its call for their immediate and unconditional release. I shall now read out the operative part of the order. For these reasons, the court, by 13 votes to 2, reaffirms the provisional measures indicated in its orders of 26 January 2024 and March 28, 2024, which should be immediately and effectively implemented. In favor, President Salam, Judges Abraham, Yusuf, Shway, Bandari, Iwasawa, Nolte, Chardsworth, Brandt, Gomez-Robledo, Cleveland, Oresco, Tladi. Against, Vice President Subutinde, Judge ad hoc Barak.